6. The first panel witnesses will please stand and raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show the witness answered in the affirmative and may be seated. I'll now introduce our witnesses. Our first witness is Chair Darrell Lindenbaugh, nominated as a Democrat in May of 2022. Prior to her appointment, the chair worked as an attorney where she advised candidates, political committees, and organizations on campaign finance and election law. Our next witness is Vice Chair Sean Cooksey, who was nominated as a Republican in December of 2020. Prior to his appointment, Mr. Cooksey served as general counsel to U.S. Senator Josh Hawley, working on the Senate Judiciary Committee and advising the senator on issues including constitutional law, judicial nominations, election law, and an array of other issues. Next, we have Commissioner Shauna Bossard, who joined the commission in 2008 as an attorney in the Enforcement Division of the Office of General Counsel. The commissioner was nominated as a Democrat in December of 2020. Next, we have Commissioner Alan Dickerson, who was nominated as a Republican in December of 2020. Prior to his appointment, he was legal director of the Institute of Free Speech, where he led a nationwide First Amendment litigation practice. We also welcome Commissioner Ellen Weintraub, who served as commissioner of the U.S. Federal Elections Commission since 2002 and chaired it for the third time in 2019. The commissioner was appointed by George W. Bush as a Democrat on the commission via recess appointment in 2002 and was confirmed by the United States Senate in 2003. And finally, we welcome Commissioner Trey Traynor, who was nominated as a Republican in May of 2020. The commissioner has practiced law for 2 decades in the areas of election law, campaign finance law, and ethics. We appreciate you all being with us here today and look forward to your testimony. Please remember the microphone's in front of you and you have to pull a little bit close to you. And I know we got all 6 of you at a big table. You'll have 5 minutes for your testimony. We'll begin with you, Chair Lindenbaum.
Thank you. Chairman Steil, Ranking Member Morelli, and members of the Commission, thank you for inviting me to speak about the Federal Election Commission. As the newest member of the FEC and this year's chair, I'm delighted to share our agency's critical work, achievements, challenges, and the path forward. The core mission of the FEC is to ensure transparency, compliance, and fair enforcement of the federal campaign finance laws. No more than 3 of the FEC's 6 commissioners may be affiliated with the same political party. Because 4 votes are necessary to approve most agency actions, we must cross party lines to find common ground on issues ranging from staffing levels, to budget priorities, to regulatory language, to enforcement matters. Of course, we'll have meaningful disagreements, but I've made the focus of my chair year ensuring the FEC is a modern, functioning agency. I'd like to share some of the many improvements and changes we've made this year and highlight some of our lesser known but mission-critical programs. I'm proud that after years of internal hand-wringing and external frustrations, we successfully revamped our audit procedures, resulting in a process that strikes the appropriate balance between efficiency, procedural protections for audited committees, transparency, and encouraging voluntary compliance with the law. In April of this year, we approved and updated our Memorandum of Understanding with the Department of Justice, which establishes the guidelines for the FEC and DOJ to share information and advance the mission of both agencies. We have 2 new open public comment periods. The first is a notice of availability of a petition for rulemaking surrounding the fraudulent misrepresentation of campaign authority through artificial intelligence in campaign ads. The second is a comment period to identify the ways to improve our filing systems and the usability of our website ahead of the 2024 elections. This also includes downloading information from our website and how you view it. Improving our hiring and personnel processes has been one of my highest priorities. On the Personnel Committee, Commissioner Traynor and I timely approve hiring vacancies and use our experience from the private sector to speed up staff hiring and find new recruitment streams so that we don't miss out on talented candidates. The FEC's educational opportunities aimed at promoting voluntary compliance with campaign finance laws continue to be a success. Our information division has excelled in creating engaging, cost-effective educational programs from the regulated community, consistently receiving high praise for their exceptional presentations. Our dedicated Information Division and Reports Analysis Division play pivotal roles, answering thousands of calls each year with substantive questions about campaign finance rules and regulations and intricate reporting questions. These callers often have limited resources to hire lawyers and other experts, so our patient and dedicated staff ensure that those engaging in the political process have access to the information and guidance they need to navigate the complexities of campaign finance law and maintain compliance. Of course, significant challenges remain that require additional funding. Historically, the FEC has not asked for or received sufficient funding to keep pace with inflation or the rapidly increasing volume of transactions reported. This has put us in a dire situation with increasingly outdated and vulnerable IT systems as the volume of transactions continues to increase. In 2022, we advocated for a meaningful increase in funding for fiscal year 2023 to allow our agency to begin meeting these challenges. Our recent successes with hiring and beginning the long overdue upgrades to our IT infrastructure are due in large part to our increased appropriation from Congress in fiscal year 2023. With continued investment in future appropriations, we can continue to build our workforce and fortify our IT systems in the face of ever-increasing spending. I've had the privilege of sitting in on staff meetings across the agency over the past few months to acknowledge and thank our staff for their work, and I have been consistently impressed by their professionalism and dedication. Despite working with antiquated systems and limited resources, our staff continue to bring energy and creativity every day to further our mission of ensuring transparency, compliance, and fair enforcement of the federal campaign finance laws. I look forward to taking your questions.
Thank you very much. I now recognize Vice Chair Cooksey.
Good morning, Chairman Steil, Ranking Member Morelli, and members of the Committee on House Administration. It's an honor to appear before you today to testify about the work of the Federal Election Commission and to answer your questions. My name is Sean Cooksey, and I currently serve as the Commission's Vice Chairman. I've submitted lengthier written testimony to the committee, but in the limited time I have, I would like to raise 2 points. First, as Chair Lindenbaum discussed, since the Commission regained its full slate of commissioners at the end of 2020, the agency has been hard at work again. Let me give you a couple of examples. In the last 33 months, we have cut our enforcement backlog by more than half, from 446 enforcement matters pending when I arrived to 198. That includes a 92% reduction in the number of reports waiting for commissioners' action, from 223 reports sitting on our desks to now just 19. Importantly, of the more than 500 enforcement matters that the agency has completed since January 2021, the Commission reached some kind of bipartisan agreement in 90% of them. Oftentimes, those cases were decided unanimously. Similar statistics are true for other areas of our work, such as advisory opinions and regulations. This is not to say that the job at the Commission is easy or that we do not frequently disagree. We do. But I assure you, my colleagues and I are doing our level best to work together, to apply the law to the facts before us, and to craft policies that fulfill our agency's mission to the American people. The second point I want to raise is a request. As Ranking Member Morelli mentioned, the commissioners before you are making every effort to improve the agency, but some things only Congress can do. The Commission's top legislative recommendation to Congress is to extend or make permanent the Commission's administrative fine program, which is set to expire at the end of this year. The administrative fine program authorizes the Commission to assess standardized fines for basic campaign finance reporting violations and to thereby avoid putting campaigns through the slower, more expensive enforcement process at the Commission. The program works well. Last year, in 2022, the Commission issued over $1 million in administrative fines. It saves the government and taxpayers money, and it promotes fast and fair enforcement of the law. That's why Congress has reauthorized the program 6 times before, but we need Congress to do it again. Last week, the House of Representatives was sent legislation that reauthorizes the program for another 10 years after it passed unanimously in the United States Senate 2 weeks ago. I would urge the House to pass S2747 and to send it to the President's desk. It is the most direct and immediate way that this committee can help improve the FEC. I would like to end with a note of thanks. First, I would like to thank the career staff at the FEC. Without them, the work of the agency would not be possible, and the agency's accomplishments belong more to them than to any commissioner. Second, I would like to thank the members of this committee and their staffs. Congress's oversight of the executive branch, and especially of independent agencies like the FEC, is critical to ensuring the democratic accountability of our government. I know firsthand that this would not be possible without the tireless efforts of dedicated staffers in each of your offices. With that, thank you again for the opportunity to testify, and I look forward to taking your questions.
Thank you very much, Commissioner, Vice Chair Commissioner. And I'd now like to recognize Commissioner Broussard. We'll hard to see the light, but it often works.
Is it? Thank you. Appreciate it. Good morning. Good morning, Chairman Stiles, Ranking Member Morelli, and members of the committee. Thank you for inviting me and my colleagues to testify today. I'm eager to highlight the agency's accomplishments before our Oversight Committee. We have had a full complement on the Commission since the Senate confirmed me and 2 of my colleagues in December of 2020. And while there have been notable challenges since then, I remain committed to transparency, fairly enforcing our campaign finance laws, and fostering an agency culture that builds on the dedicated efforts of my former colleagues at the staff level. I consider service on the Commission a privilege. Indeed, my commitment to the agency and its mission began long before my appointment, beginning in 2008 as a staff attorney in the Commission's Enforcement Division and later as counsel to a commissioner. Those experiences allowed me to develop not only legal knowledge, but an understanding of the agency that gives me a unique perspective represented on the Commission. Today, I can look back on almost 3 years on the Commission with a measure of satisfaction and some concern, and I look forward to future years with continued dedication and hope. I take satisfaction in having led the Commission's dramatic reduction of the enforcement docket backlog, following a loss of a quorum of 15 months and under the uncertainty of a global pandemic and an executive order for government-wide remote work. When the quorum was restored, the backlog stood at 450 matters and slightly exceeded that number when I assumed the chair in January 2021. This was almost 75% from when the Commission lost the quorum. But by October of 2021, through a disciplined and methodical approach, the Commission had closed 194 matters, which was the highest number achieved since fiscal year 2009. While I'm proud of this achievement, I'm not oblivious to the potential for a backslide with the likely increase in the number of agency actions as we enter a presidential election. But at the same time, the Commission has experienced significant attrition. Agency staff levels thinned to 260 at fiscal year 2022. This means that fewer staff shoulder the rising workload, which risk a negative effect both on employee morale and on the agency's capacity to timely respond to enforcement matters and advisory opinion requests. But thanks to the effort of Chair Lindenbaum and Commissioner Traynor, as of today, our agency FTEs stand at 305 with more to come. Above all, I am hopeful. On the Regulations Committee, I advanced a long-standing rulemaking with the joint effort of my co-chair, Commissioner Alan Dickerson, whose keen analysis only sharpened our focus and won wider support for our efforts. Significantly, since 2011, the Commission had been considering an internet disclaimer rulemaking. Last December, the Commission published a final rule. Beginning last year, I have led an effort that is a passion of mine. The issue, the ability for candidates to use campaign funds for compensation while they are campaigning, has both a macro and micro implications. On a micro level, it's about opening the possibility of running for federal office for a diverse population. On a macro level, it enables our democracy to become more perfect by creating opportunities for our federal elected bodies to reflect the demographics of our nation. In December of 2022, the Commission formally initiated a rulemaking, and we are now in the process of negotiating final rules. Finally, after a 3-year lapse, in 2021, the Commission submitted bipartisan legislative recommendations that can help strengthen the agency and the laws we enforce. I was excited to see the Senate pass a bill to extend the admin fines program for 10 years. But I also want to urge this committee that bipartisan support in strengthening FECA, the prohibition against all foreign national involvements in our campaign process, is needed. In closing, I am inspired now as ever to serve the Commission. Your continued support can help fulfill our mission, and doing so, cultivate public trust in our electoral process and elected officials. I thank you again for the opportunity to appear today.
Thank you, Commissioner Broussard. Commissioner Dickerson, you're now recognized.
Good morning. Thank you, Chairman Steil, Ranking Member Morelli, members of the committee. I also want to begin by thanking you for holding today's hearing. The Federal Election Commission's been given an especially delicate mission, regulating activity at the core of the First Amendment's protections for political speech and association. Precisely because that work is difficult, we do it best in dialogue with Congress and the courts. After more than a decade without a formal oversight hearing, I am honored and gratified to join my colleagues here today. This is a new commission. On a body designed for staggered 6-year terms, 5 of us have served for less than 4. We inherited an agency that had lacked a quorum for virtually the entirety of the 2020 election cycle, and where a backlog of enforcement cases and regulatory matters had grown to an unprecedented level. Today, joining the chorus, the situation is very different. Taking the gavel on virtually her first day as a commissioner, Shauna Broussard drove hard to resolve hundreds of stale enforcement matters and to clear the decks for future work. And that vital effort has allowed the commission to focus on long-needed reforms. More than a decade after the D.C. Circuit's decision in Speech Now versus FEC, we amended our PAC organizational forms to recognize the existence of super PACs. We successfully concluded a rulemaking on internet disclaimers that had laid dormant since 2011. We completed a top-to-bottom review of our auditing procedures. Each of these decisions was made on a resoundingly bipartisan basis. These successes illustrate, I think, the leadership of my colleagues and our willingness to work with each other to find common ground against a challenging legal backdrop. It's common to begin discussions of the FEC by invoking Judge David Tatel's pointed observation in AFL-CIO against FEC, that the commission is unique in that it has as its sole purpose the regulation of core constitutionally protected activity. And that's certainly true. But the late Justice Antonin Scalia put his finger on perhaps a deeper problem. He observed that campaign finance law is so intricate that he couldn't figure it out. That complexity is the result of Congress's consistent failure over decades to update the law to respect judicial precedent, with the commission and ordinary Americans caught in the middle. And it's not new. Back in 1976 in Buckley versus Vallejo, 7 members of the Supreme Court, including Chief Justice Burger, but also including Justices Thurgood Marshall and William Brennan, held that the phrase, quote, "for the purpose of influencing an election," end quote, the keystone term in the act, was unconstitutionally vague. Such a distinction, they noted, offers no security for free discussion. In these conditions, it blankets with uncertainty whatever may be said. It compels the speaker to hedge and trim. As a result, we're unique in another way. We're the only federal agency whose governing statute has been in judicial receivership since its inception. So much of the act has been held unconstitutional over so long a period of time that with every passing year, it becomes more difficult for ordinary Americans and even most specialists to understand what is and is not permitted. There are many downsides to this state of affairs, but I want to highlight just one more. Because the text of the act and the reality of the law are so qualitatively different, it is easy to fall into false certainty about what the law actually is, and all too easy to perceive illegality rather than thorny questions, especially where one's political opponents are involved. Because the Commission's enforcement efforts are driven in large part by third-party complaints, there's a clear incentive to use the complaint process and to suggest, from ignorance or malice, that a novel question is in fact clear or obvious, and to blame the Commission when it takes seriously its duty, as the Supreme Court put it, to ensure that the tie goes to the speaker and not the censor. Fortunately, while my colleagues and I sometimes disagree on the correct interpretation of the law in particular cases, I do believe we share a commitment to simplifying and explaining the law so that average Americans who wish to participate in our political process may do so without peril. As Justice Kennedy, writing for the court in 2010, properly stated, the First Amendment does not permit laws that force speakers to retain a campaign finance attorney before discussing the most salient political issues of the day. Thank you again for the invitation. I look forward to your questions.
Thank you, Commissioner Dickerson. Commissioner Weintraub, you're now recognized.
Chairman Steil, Ranking Member Morelli, and members of the committee, thank you for inviting me to testify today. I'm pleased to be here with my colleagues on behalf of the Federal Election Commission to discuss the important work of our agency. I can't say this is the most exciting thing that I'm doing this fall because my daughter's getting married in a couple of weeks, but this is a close second. The FEC is charged with administering and enforcing the federal campaign finance laws and providing public disclosure and transparency in our elections to empower a well-informed electorate, a goal the Supreme Court has robustly endorsed since the seminal 1976 case of Buckley v. Vallejo. I sit at this table with my fellow commissioners, but the agency is not made up of only 6 individuals. While we take the votes, we cannot fulfill this agency's crucial mission without the hundreds of people who are not at this table. Our FEC staff is made up of some of the most dedicated public servants I have ever met. They are diligent, thoughtful, and provide great service to the American people. I would be remiss if I did not take this opportunity to thank them for all of their hard work and commitment to the mission of our agency. The FEC has been through a lot in the last few years. We went through a total of 15 months during the record-shattering fundraising of the 2020 election when we did not even have a quorum of commissioners to make decisions. That ended at the end of 2020 when we regained a full complement of commissioners for the first time since 2017. We have been pretty busy ever since. Not surprisingly, we had quite a backlog of enforcement decisions to make when we regained the quorum. But we were fortunate in 2021 to have the steady and determined leadership of then-Chair Broussard, who made attacking the backlog a top priority. Thanks to her efforts and the continued focus by 2022 Chair Dickerson and 2023 Chair Lindenbaum, and the hard work of all of my colleagues, we have virtually eliminated the backlog of cases awaiting decisions by the Commission for the first time in many years. Now, I didn't agree with the outcomes of each of those decisions, but eliminating the backlog so that cases do not languish and fall due to the statute of limitations is an important accomplishment. Public confidence in the political process depends not only on laws and regulations to ensure transparency, but also on the awareness that those who disregard the campaign finance laws will face consequences. In that regard, I want to highlight the updated Memorandum of Understanding with the Department of Justice that the Commission adopted in April of this year. I want to thank Vice Chairman Cooksey for partnering with me on an ad hoc committee to oversee this project, and I particularly want to thank the leadership of the Department of Justice, who made this a priority and worked cooperatively with us to get it done. I believe this agreement will aid in effective enforcement of the law, a goal that the American people expect and deserve. So there have been accomplishments, and I want to thank Commissioner Traynor, who serves with me on the press committee, for helping to ensure that the public is informed about those accomplishments. But as always, there is still plenty of work to be done. We have made strides on the rulemaking front, thanks to the efforts of Commissioner Broussard and Commissioner Dickerson on our Regulations Committee. Important rulemaking projects are ongoing, such as our efforts to update our rules on candidate compensation to make it possible for citizens from all walks of life to consider public service. Here, too, however, we face a backlog of projects. It has been more than 13 years since the Supreme Court's Citizens United decision and its progeny created the entities we now know as super PACs, but we have yet to promulgate regulations governing them. Our coordination regulations have not been updated to take into account the significant role that super PACs now play in the campaign finance arena, and the old rules are not adequate to bear the weight that has been placed upon them. Citizens United reiterated the importance of disclosure, the heart of the FEC's mission. The court explained that disclosure enables the electorate to make informed decisions and to give proper weight to different speakers and messages. Or as Justice Scalia put it in his concurrence in Doe v. Reed, requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed. Undisclosed dark money is a large and growing problem that undermines the court's promise of transparency and the FEC's fundamental mission. The FEC can and should do more to address it, and we have just begun to deal with new challenges such as the potential role of artificial intelligence in campaigning. I want to echo my colleagues' advocacy for our unanimous legislative recommendations, including extending the successful administrative fine program and amending the FECA to expand protections against foreign influence. And I'd like to put in a plug for our budget request, which would allow the agency to continue to meet its increased workload and make needed updates to the agency's critical IT infrastructure. Progress has been made, but challenges remain. Dark money, foreign malign influence, new technology, cybersecurity, AI, budget constraints. These are just a few of the issues confronting the FEC. I stand ready to work with my colleagues at the FEC and with our oversight committees in Congress to address these challenges. I look forward to a productive exchange here today toward that goal.
Thank you, Commissioner Weintraub, and congratulations to your daughter on her wedding. Commissioner Traynor, you're now recognized.
Thank you, Mr. Chairman. Thank you, Chairman Steil, Ranking Member Morelli, and members of the committee. It's an honor to appear before you today and to answer your questions. As I noted in my written submission, and as you've heard here, there's great bipartisan work being done at the FEC. Today, however, I'm compelled to draw the attention of this committee to a disturbing situation that has become increasingly prevalent in today's politics. To those who've been paying attention, the problem is stark. It's the growing weaponization of government to harass and hinder the political participation of our citizenry in the democratic process. The Federal Election Commission has become a weapon in two specific ways in that process. First, the Commission adopted new procedures that I believe are inconsistent with our statute and may violate the Constitution, and are the gateway to criminalizing ordinary campaign activity. Second, the Commission entertains vague complaints regarding alleged violations of the Federal Election Campaign Act to the detriment of the rights of innocent respondents. Make no mistake, the current headlines about the criminal prosecution of political actors reflects a trend that is going to continue for the foreseeable future. Unfortunately, the Commission has become part of that problem. Earlier this year, the Commission and the Department of Justice entered into a new memorandum of understanding regarding how information will be secretly shared between two agencies. The Commission was established as an independent executive agency. As such, the Commission operates outside the normal procedures of the executive branch, and specifically in a bipartisan manner. However, the new MOU brings the Commission squarely into the fold of executive agencies that routinely share information amongst themselves. Most disturbingly, members of the public are not given notice that their interactions with the FEC are memorialized by bureaucrats and could form the basis of criminal investigations. This is not just a hypothetical situation. Requests by the Department of Justice for us to stand aside so they can pursue a target are on the rise. Since I joined the Commission, there have been abatement requests related to 33 different matters, and most include document production requests. Critically in these cases, the Commission has acquiesced to the request to not alert those being investigated. The information has been requested by the Department of Justice. I believe this new MOU retards the First, Fifth, and Sixth Amendment rights of citizens who are actively engaged in the political process. I strongly believe that this information sharing should be halted and the independence of the FEC should be reaffirmed. Secondly, the Commission is seeing a significant number of complaints against so-called unknown respondents that a complainant alleged that someone or entity, the identity of which is unknown, has done something illegal. The Commission has received over 30 of these complaints since 2020, and they're problematic for two reasons. First, an unknown respondent complaint outsources a complainant's obligation to file an informative complaint. Compounding this problem is that such complaints are typically filed by ideological organizations that see an opportunity to have the legwork done at the taxpayers tab without regard to whether those allegations are true. Take, for example, the case of Mr. Derek Utley. Mr. Utley was an unknown respondent in a matter that ultimately took 4.5 years to dispose of. What was Mr. Utley's heinous act? He engaged in constitutionally protected free speech by anonymously publishing a Facebook page entitled Elect Trump 2020. So how did it happen? Well, a poorly sourced news article alleged that an unknown person, later identified as Mr. Utley, spent over $34,000 on shady Facebook ads. In 2017, a complaint was filed by Common Cause. In 2019, based solely on the news article, the Commission found reason to believe that a violation had occurred and launched an investigation. The result of the investigation? Mr. Utley had actually spent $483 on Facebook ads which should be protected activity under settled precedent by the U.S. Supreme Court. Mr. Utley's case is the textbook example of how the process has become the punishment. The ultimate outcome of Mr. Utley's multi-year harassment by the FEC was that his case was closed. Not closed with an exoneration, not closed with an apology for the bureaucratic inquiries that he had to withstand, or the amount of money that he expended. It was just unceremoniously closed. All the while, the media outlet that misreported the facts and the group that filed a complaint without doing its own research walked away, having made Mr. Utley an example of anyone who dares share his political views. In conclusion, I'm proud of the bipartisan accomplishments we have at the FEC. However, at the same time, I am fearful of the continued weaponization of government against political participation. If this weaponization continues, I fear that American citizens will ultimately choose to forego participating in our political processes. That would be unfortunate, as their participation is the foundation of our republic. Sitting here as an FEC commissioner, I urge Congress to halt the secret sharing of information between the FEC and the Department of Justice, and to clarify that only complaints based on actual evidence are investigated by the Commission. Thank you, and I look forward to your questions.
Thank you, Commissioner Traynor, and thank you to all